with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not relevant.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy there.
Got the wrong guy. The dog was biting him.
He roughing him up quite a bit. There's a lawsuit.
Wake up in the morning wearing headphones. I'm running court into your brain like it's an end zone. My money's green like the pickles and you want some. Don't interrupt cause I don't want your lame objection. From land t-shirts to murder, I think I've seen it all. From picking juries to when the gavel falls. The judge takes the bench and the bailiff yells, all rise and pay respect to the one and only go to true crime. Imitators, they try but they just can't achieve. And when they fail, they be like, ow, I stepped on a bead. Take the stand and the jury chooses not to believe. Because there will never be another creator like me. Big deal in one corner and the count in another. We've got the judge reading chat while we talk to the lawyers. All our clips go viral, they're the good not to share. Came in late, check the thumbnails, you'll find it all there. They say I'm addicted to rhyme, but it's more than just time. And the mic is hot, the gavel drops, and I'll be talking about crime. And don't you worry about the sound, cause I'm keeping it real. Just like a pickle jar, but I'm one big deal. They say I'm addicted to rhyme, but it's more than just time. And the mic is hot, the gavel drops, and I'll be talking about crime. And don't you worry about the sound, cause I'm keeping it real. Just like a pickle jar, but I'm one big deal.
There we go. We've got Big Dill as a sound intro because I deleted the other one. Amber's finding it for me. I deleted the Letitia Stout soundbite where she says, what they say, what was the next search on February, whatever. And she says, how does the FBI find people? I deleted it. I still have the...
I object.
I've got that part, and I've got the...
Did the defendant find out how the FBI finds people in this case? Or she found out?
I've got that. I just have the first part I'm missing. Anyway, welcome back to the Court of Public Opinion. I am the Recovery Addict, or Big Dill, as we're going by today. I'm Big Dill. That was a little AI song we created when we were following a gang case, and we learned so much about gangs we just decided to form our own. And yeah, and there's the song. So, all right, welcome. Greeners first in chat today. Congratulations, Greeners. Full confession, I may have led you guys astray. I may have told you that that the first person in chat on YouTube gets bonus points. I think it's the first person in chat once the seats start working, if that makes sense. So as soon as Lumia Stream recognizes that I'm live streaming, the next person to chat, I think they win. What that does is it basically opens up the points to some random person 30 seconds into the live stream. So this might be good news for everyone with Greeners, is what I'm saying. It might be good news for everyone but Greeners. All right, JT's like, that's what I was saying. I was trying to tell you, and he wouldn't listen. I'm sorry. I listen now. It makes sense. Came together. Greeners like, this blows. It's terrible. I'm sorry. I don't know who got the points. Greeners, you can check your points. It might be you. It might be. Maybe I'm wrong. Maybe it goes back and looks at the top chat. Check your points, Greeners. See where you're at. You're probably winning. All right. Greeners is checking points. We'll see. Of course, it's not responding. There we go. Points for Greeners is... Yeah, you're not, Greeners. You're still... Well, at least you haven't caught up with yesterday's Greeners. 3, 4... Really, Greeners... You're sort of slacking. Oh, you changed your name, didn't you? You changed your name. I knew it. All right, hang on 1 second. I think we're...
At this time, I would direct the defendant, Mr. Valle, to please retake the witness stand.
I think we're coming back. Hold on just 1 second. We are. We're coming back.
I'll just
That was
remind you
quick.
that you do remain under the obligations of the oath that you took when you went to the witness stand.
We're back from lunch. Still under cross-examination. Just waiting for the jury.
Ladies and gentlemen, the jury counsel, please stipulate to the return of our jurors.
State will stipulate, Your Honor. Defense stipulates, Your Honor.
All right, I'll direct the state to continue this cross-examination.
Thank you, Your Honor. So, Lito, after you stabbed Jimmy McGrath on May 14th of 2022, you indicated on direct examination you dove towards the car. You remember that?
Yes.
And then you indicated you got into the front passenger seat of the car, right?
Yes.
And when you got in the front passenger seat of the car at that moment, Tyler DeSilva wasn't in the car at that moment, was he?
No.
Tyler got in a few moments after you, right?
Yes.
And before Tyler DeSilva gets in the car, you tell Jack, "Oh my fucking God, I just stabbed 4 kids," correct?
No. When I first got into the car, he tried to drive off, and I said, "Wait."
So you don't admit to Jack that you stabbed 4 kids?
No.
But you would agree with me that, in hindsight, you did stab 4 kids, right?
I didn't know who I stabbed, or where I stabbed him, or when.
I'm going to ask a very simple question that requires a yes or no answer. You would agree, in hindsight, that you stabbed 4 kids, correct?
I don't know who got stabbed or where they got stabbed.
As you sit here today, you would agree that you stabbed 4 kids, correct?
Yes.
So at some point, Tyler gets in the car, right?
Yes.
And the car is facing, if I may approach the witness, Your Honor. States 1. The car is facing Adams Drive, correct?
Yeah.
And you get in the car and Jack drives straight, correct?
Yes.
And he takes a left down Adams Drive, right?
I'm not sure.
So you were not paying attention as to where you were driving? But at some point in time, very shortly after you getting in the car stops in a cul-de-sac, right?
I don't know where it stopped.
And you get out of the car with the knife and throw it into the woods, correct?
No.
So your testimony today is that you get out of the car, you tell Jack to stop, right?
Yes.
You get out of the car, right?
Yes.
And at that moment, the one thing you were concerned about was looking at your ribs. That was your testimony on direct?
Yeah, I had a very sharp pain on my rib.
You weren't concerned with the fact that you just stabbed 4 kids at that point, right?
I didn't know who got stabbed or where they got
But
stabbed.
you recall stabbing some kids at the party, right?
I was just flailing my arm around.
So you had no idea you stabbed anybody at the house?
No.
You were just flailing back and forth like this, swiping motions.
Everything.
When you got in Jack's car, you didn't call the police at that point, did you?
No.
In fact, after you drove, when you first got to 43 Laurel Glen and you drove down the street, you didn't call the police at that point, right?
No.
And you didn't call the police when you got out of the car down the street at the intersection of Laurel Glen and Farmhouse Lane, correct?
No.
And you didn't call the police just slightly before you went back to 43 Laurel Glen, right?
No.
So at some point you get back in the car after checking your ribs, right? You determined you were okay. There was nothing was going on. You used the light from inside of the car, right? That's your testimony?
Yes.
You get back in the car and you drive back to where Will, Mackenzie, Dimitri, and Keenan were, right?
There was nobody
There was nobody there?
No, they were in the car.
So Mackenzie's sister was already there.
Yes.
So my point is you drove back to the area where those kids were, your friends, right? And your girlfriend.
Yes.
And at that point, you say to Jack and Tyler, stop the car, right?
Yes.
And you say, I love you guys, I'm going with Kenzie, right?
I don't remember if I said anything. I just remember going and getting in.
And you get out of the car.
Yes.
And they take off. Tyler gets in the front seat. Do you recall Tyler getting in the front seat? They take off, right? You remember seeing them take off?
No.
You don't remember? You just remember you getting in the car and that's it?
And then we drove off, yeah.
Okay. Now, you were in Mackenzie's car, and you were listening to music.
Yeah.
It was a quiet ride, right? Outside of the music. There was no talking, right?
Keenan talked to me.
Keenan was talking. And when you got into Mackenzie's sister's car, you didn't call the police at that point, right?
No.
Because you were shocked, right? You were shocked at that point?
Still panic and everything.
Panic? And you indicated that you didn't realize you stabbed anybody, but you were still in a panic?
Yeah.
And you indicated that you dropped off Keenan and Dimitri, right?
Yeah.
Mackenzie was still upset. She didn't want to talk to you.
Yes.
And in fact, when they dropped you off in Milford, you asked to talk to Mackenzie, right?
Yes.
And she would not talk to you, right?
Yes.
And you got inside your house,
Yes.
and you got inside your house after midnight, right?
I don't remember the time.
It was late, right?
Yeah.
Would you agree that the video from 36 Laurel Glen has 11:40 when you initially go down the street and about 11:53 when you're taking off and leaving the area for good? Do you recall that?
I'm not sure what time it was.
But it was late, right?
Yeah.
And your mother's packing for Florida.
Yeah.
And your brother's packing for Florida
Yes.
because you had an early flight. And you weren't going at that point, right?
They-
Just prior to coming home, you were not going to Florida?
Yes.
Right. But when you got home, you decided you were going to Florida at that point, right?
When my mom had asked me, yes.
And you had told your mother what had happened, right?
Bits and pieces.
And at that point in time, you didn't call the police.
No.
You didn't tell them your side of the story, right?
Even after, the police never asked me anything.
All right, I'd move to the strike as non-responsive, Your Honor.
I will strike the witness's testimony following the response of no, ladies and gentlemen.
So you didn't call the police that night, right?
No.
As a matter of fact, while Mackenzie is driving home, she engages in a text message with you, right?
Yes.
States 97. Around 12:26 a.m., right? This is when the text messages are going on. You're already home at this point, right?
Yes.
She's driving home at this point, right?
I have no idea.
You texted with each other shortly after her dropping you off, correct?
I don't remember when. I just know I texted with her.
Within how long?
How long what?
How long were you home before you started texting?
I don't know.
You don't recall. But in any event, you talk to your girlfriend, and you tell her, I didn't do anything, I wasn't there, stop texting. You know that was a lie, right?
Yeah, I was just panicking. I didn't know what to say.
States 98. Again, I wasn't there. That was a lie, right? Because you were there, right?
Yeah.
States 99. Don't text me, I'm going to Florida, right?
Yeah.
So at that moment in time, what you thought was important was to go to Florida instead of calling the police, right?
I didn't know what to think.
My question to you is, at that point in time, you decided to go to Florida instead of calling the police, right?
I don't know what I was.
Did you call the police in this moment? No, right? So at that point in time, you said, I'm going to Florida, right? You told Mackenzie that, right?
I texted her, yes.
You didn't say, I'm calling the police, right?
No.
Because you told her you weren't there, right?
I was just freaking out. I didn't really know what to say.
States 100. I can't text anything, I wasn't there. You can't text anything because Why? Because you're afraid of making an admission?
No.
And again, you're saying I wasn't there. That's 3 times. You're telling your girlfriend who was with you at the scene that you weren't there. Right?
Yes.
So you go to Florida early the next day with your mother and your brother, right?
Yes.
And you were going to Florida to see your other brother, right?
Yes.
And what was your other brother doing in Florida?
Living
Living? Where was he living?
in Stuart, Florida.
Stewart? And you were down there for a day?
I don't remember how long I was down there.
Do you remember flying home with your mother on Monday night, the 16th of May?
I remember flying home. I don't remember exactly what day it was.
You indicated on direct examination that you found out the severity of what had happened when you were in Florida, right?
Yes.
Now, who did you find that out through?
I can't remember exactly, but one of my friends had texted me.
One of your friends had texted you. And when you found out the severity of what had happened while you were in Florida, you didn't call the police at that point either, did you?
No.
Do you recall the day that you flew home?
No.
Would looking at a document help to refresh your recollection?
Sure.
May I approach the witness, Your Honor? Do you remember to refresh as to when you came home?
Yeah.
When did you come home?
Showed me that at like 7 or 10 p.m.
10 p.m. on the 16th, right? And at some point in time on the 16th, were you aware that there was a warrant for your arrest?
I think at that time, no.
No? And you indicated that the next day you slept late? Were you sleeping to the afternoon?
Yeah. No, I
And
was sleeping, like,
you were sleeping. And at some point you found out that there was a warrant for your arrest, right? But you didn't turn yourself in when you woke up, right?
Yes, I got in the car with my dad and instantly.
Isn't it true you didn't turn yourself in until 4 in the morning on Wednesday, the 18th?
Yeah, it was around that time.
So it wasn't the next day after you got home from Florida, right?
I don't remember when it was.
At some point in time after the incident on May 14th of 2022, Tyler De Silva texts you, or calls you on the phone, rather. Do you remember that?
Never called me.
And you had a conversation with him, right?
Never called me.
And you told him you fucked up, right?
Never called me. I called him and he never answered.
So on the 18th of May, when you turned yourself in, the police took pictures of you that counsel went through with you, right? And this is a picture, states 34, that's a picture of the front right side of your face, right?
Yes.
No blood, no serious contusions like Ryan Hines, right?
This was days after.
Days after, so you're a quick healer?
Yes. Right. The pictures of Ryan Hines were the same day, I think.
States 35. No serious contusions on your face, right? No serious black and blues, right?
No, this is
Right? This was 3 days later, right?
I don't know how many days.
States 36. Got a little bit of the black and blue on your left eye there, right? But nothing huge, right? Right?
Objection, Your Honor. These speak for themselves. He's asking him to give an opinion on the medical injury.
Right? You don't have the serious black and blue on your eye, right?
Guess not.
States 37. The rear of your head, can't really see any serious contusions on the back of your head in this picture, right? 4 days later?
I see one.
You see one? Where do you see it?
On the left side?
On the left side, right. So we have states 38. We can show that right here. Again, not really that area there. 4 days later. Doesn't really look like the black and blues that Tommy Connery had a month later, right? Doesn't really look like the black and blues that Ryan Hines had on the side of his body.
Objection, Your Honor. Asking him to make a comparison between somebody else's injuries and what are in these photos, it's improper.
That's the state of his argument.
And you have a scratch mark, states 40, right? It's a little scratch mark on your right arm?
Yes.
States 42, no real marks on your hands, right?
No.
States 43. Again, no marks on your hands, right? So just to confirm, on May 14th of 2022, you were the only one with a knife at Tyler Rich's house, correct?
No idea.
Did somebody else have a knife at Tyler Rich's house?
Not that I know of.
You didn't see anybody else with a weapon that night, right?
I didn't look for any weapons.
You didn't see any, did you?
I didn't look.
You didn't see any, did you?
No, I didn't look.
There were 4 people that were stabbed that night, right?
Yes.
And those 4 people had 9 stab wounds, correct?
I believe so, yes.
And you're the one responsible for that, correct?
At the time, I didn't know who got stabbed or where they got stabbed or when they got stabbed.
You're the one who was responsible for those stab wounds, correct?
I don't know. I guess so, yes.
No further questions, Your Honor. Thank you.
Briefly, Your Honor.
Briefly? You need like 2 hours to go back over
Mr. Valle, do you remember Mr. Durso asking you about having an interaction with some of the Shelton High kids at the intersection of Laurel Glen and Farmhouse Lane?
Yes.
And we saw a video of the vehicle coming by, and you testified that that's when Mr. Snyder gave you the knife?
They tossed it to me, yes.
And then you saw some of those Shelton High kids come up and approach you, right?
Yes.
And you had the knife then, right?
Yes.
And you got sprayed in the face with WD-40?
Yes.
Why didn't you use the knife then?
I wasn't in fear of my life. I had no reason to use it.
You went back down to 43 Laurel Glen Drive in Jack Snyder's car, right?
Yes.
You had the knife that Jack Snyder had given you at that point, right?
Yes.
You used it then?
No.
You used it when you got down there and you were confronted with those kids and you're on the ground as you've described for us here?
Yes.
Why?
Felt like the only thing that was going to save me.
Nothing further.
Mr. Valle, you had the knife when you were down at the corner of Farmhouse Lane and Laurel Glen, right?
Yes.
And you willingly got back into Jack's car, right?
Yes.
And you went back to Tyler Rich's house, right?
Yes.
And you willingly got out of the car at Tyler Rich's house, correct?
To make peace.
You got out of Tyler Rich's car with the knife, correct?
Yes.
And you walked onto the property at that point, correct?
Yes.
You had no right to be there, correct?
I don't know.
You didn't have an invitation to be on the property, correct?
When we first arrived, it's not like they came and threw us out or anything.
Well, you told us before, sir, that you were scared and panicked for your life when the kids were rocking and throwing things at the car, right?
Yes.
You didn't want to be there in that situation, right?
Yes.
But you went back with a knife to Tyler Rich's house, the very same house that you were in the car, and with things being thrown at where you were panicked and scared, right?
The knife was already in my pocket.
Right.
Yes.
But you went back to that house where you said you were panicked and scared in the car minutes before when they were rocking and throwing things at the car, correct? And you got out of that car with the knife to go confront those kids, right?
I didn't go and confront them because I...
But you got out of the car with the knife, right? And you walked on the property.
Yes.
No further questions.
Nothing further, Your Honor.
Please get to step as the Does the defense intend to call any additional witnesses?
The defense does not, Your Honor. The defense would rest.
Boom. There we go. Redirect.
The state intends to
May I have a moment, Your Honor?
Certainly.
Your Honor, state has no further witnesses. State rests.
All right. It's
So no
done.
rebuttal.
It's time for a poll.
Your Honor, at some point may the jury be excused for legal arguments.
Certainly. But at this point in time, I am actually going to I should send the jury. You want me to send the jury home at this point? Or?
That's fine.
No objection, Your Honor.
All right, so the court is going to release the jury for today, okay? So I just want to remind you that we are at the part of the trial where you have heard all of the evidence that you're going to hear in this case. However, you've not yet heard closing arguments. You've not yet heard the instructions regarding the law that you're to apply to the facts you find in this case. As such, as in my prior instruction to you on your oath, you're not at a point where you can discuss this case with anyone, including each other. So you're not at that point yet, despite the fact that you've heard all the evidence. So it may seem natural that you are at the phase where you can talk about this with your fellow jurors, but you cannot, all right? So you need to continue to abide by that instruction until such time that I tell you that you are able to go ahead and conduct your deliberations. So we are going to adjourn with respect to the jury right now for the day. You are able to leave. Again, we will not be having court on this matter tomorrow, and next to you on July 3rd, at which time I would anticipate closing arguments and the instructions, and then thereafter deliberations by you, the jury. Okay, so please, again, remember not to discuss the case with anyone. Do not take in any information about this case. Try to avoid the media as best as you can. There is a lot of media attention on this case that includes social media and news coverage. So if you can please avoid those, or would much appreciate it so that we don't have to deal with any conflicts when you come back. Also, again, there have been locations that have been discussed. Do not do any drive-bys. Do not look up any locations via any other type of mapping device. And last but not least, please do not conduct your own independent research or investigation into this case, because you are going to be instructed to decide this case based solely on the evidence presented here in this courtroom. With that, have a good afternoon, have a good day tomorrow, and we will see you back on Thursday. Thank you so much for your continued attention.
When the jury votes, they will vote guilty or not guilty. None of them will vote hung jury. That's why there's not a hung jury on the poll. I worded it intentionally that way. But we have now completed the evidentiary portion of the trial. Everything the jury has to consider has been presented. I was a little underwhelmed by the briefness, the brevity of the redirect. Wow. 2 questions and that's all? The argument here, I imagine they're going to make is one that says the state has not proven that it was not self-defense, where that burden does fall on them.
Legal argument.
Yes, Your Honor. At this point, we would move for a motion of judgment of acquittal under Practice Book 42-42. The state's evidence has closed. We made our motion at that time. We've now heard from Mr. Valle, and I would renew my motion, and I would direct the court to the cases of State versus Carpenter, 214 Con 77. It's a 1992 case, and State versus Thomas, 210 Con 199, a 1989 case. And the standard here is well known to the court. This is to be viewed in the light most favorable to the state. But even when viewed in that light, this evidence is insufficient for this jury or any jury to find beyond a reasonable doubt that Mr. Valle had the specific intent to murder anyone, that Mr. Valle had the specific intent to assault Tommy Connery or to assault Ryan Hines, and more so even with regard to Mr. Faison Teal, which is the assault in the second-degree charge. The evidence as to Mr. Teal, candidly, is we heard the least about it. We really don't have any indication of what the mechanism was. Mr. Teal couldn't be sure how he got cut or what exactly it was that cut him, and we haven't heard any evidence of anybody viewing that happening. And so it has to be simply an inference that a juror would draw that in the course of this brawl and this chaotic scene, that somehow Mr. Valle cut Mr. Teal. I would submit that that is an inference that is unreasonable to draw on this evidence that we have before us. Specific intent is not simply general intent. So the fact that Mr. Valle has testified here that he was flailing around with the knife trying to defend himself is not sufficient to show the specific intent to stab Tommy Connery, the specific intent to stab Faison Teal, or the specific intent to stab Ryan Hines, or the specific intent to stab Jimmy McGrath. As to the other elements, candidly, we have conceded those elements by raising a self-defense claim. That doesn't, however, mean that the state prevails, even when you view this evidence in the light most favorable to the state. That they have shown beyond a reasonable doubt for these fact finders
that it was not self-defense.
That Mr. Valle possessed the specific intent to murder or to assault any of the injured in this case. Consequences are tragic, but it simply doesn't tip the scales any further and allow this jury or any other jury to find, again, that the state has proven specific intent. The evidence there is equivocal at best, but in no way does it reach that highest standard and overcome it. We would ask the court to grant the motion for judgment of acquittal as to all the charges.
Attorney Joseph.
Your Honor, thank you. I would just first start by saying the defendant has testified and is now subject to the same credibility instruction that every other witness is subject to when you charge the jury. The jury is free to believe all, some, or none of the defendant's testimony, and that's up to the jury. I would submit that there are a lot of inconsistencies in the defendant's testimony, and I would submit that the defendant was caught in a lie multiple times in his testimony. And I would submit that that would have an impact on this jury. With regards to the defendant's specific intent, should the jury believe that the defendant went back there with a knife, his intent was purposeful, and that he took that knife out of his right pocket, opened it up, and started stabbing the people that were before him. There was evidence that Faison Teal, Ryan Hines, and Tommy Connery were in the vicinity of where Mr. Valle was. He stabbed Ryan Hines and Faison Teal first. They were stab wounds, not slashes. So the jury can infer from the circumstantial evidence from Faison Teal that his wound was a stab wound, purposeful, not slash. There was some testimony from doctors with regards to that. The jury could also view Mr. Hines' evidence that he was stabbed purposefully this way, not a slash wound or flailing around. The jury can infer the defendant's intent from that. With regards to Tommy Connery, there was evidence that the defendant was down almost on one knee, that he purposefully went at Tommy Connery and stabbed him 4 times in the leg. And with regards to Jimmy, after he came back from the car, when Mr. De Silva was no longer in harm's way, he turned right at Jimmy and purposefully went out and stabbed him in the heart. He didn't slash him, stabbed him. I would submit that the jury's going to get an instruction that intent can be formed in an instant, and they could also infer from the circumstantial evidence, should they not believe the defendant's testimony, that the number of wounds inflicted, the area of the bodies where the wounds were inflicted, all points to the specific intent of the defendant on May 14th of 2022. So I think when you view all the evidence in the light most favorable to the state, Your Honor, I think the defendant's argument fails, and I would ask you to deny it at this point.
So this motion being made at the close of evidence in accordance with our rules of practice, the court is going to take the motion under consideration and defer a decision until the jury returns its verdict.
Defers.
So again, there
No
won't
decision
be any
made.
court proceedings tomorrow on this particular matter, and we will see everyone back on Thursday, July 3rd. I would instruct counsel, please, at some point, just to touch base with me for an informal charging conference. I intend to be on the record on July 3rd. In the morning, we'll start with the formal charging conference on the record, at which point in time thereafter we'll move to closing arguments, and then the court will charge the jury. Okay.
Very good, Your Honor.
Thank you, Your Honor.
Thank you. Court stands adjourned.
All rise, court adjourned.
There we go. And as we adjourn court for the day, I'm surprised the defense did not make an argument about self-defense. Here's how it works. This is common in most states, as it is in Connecticut. When self-defense is claimed in a criminal case, the defendant has the initial burden to raise the evidence producing that claim, to support that claim, to say it was self-defense. They have to raise the issue. Once the issue has been raised and evidence has been provided and testimony is sufficient to do that, the burden then shifts back to the state for them to prove that it was not self-defense. They literally have to prove that it was not self-defense. I'm looking at the cross-examination of Raul, and I don't see that they've proved it there. They basically said, we don't believe you. They didn't provide any other testimony than that. It was all questions. The lawyer's questions are not evidence. I don't see where the state proved it was not self-defense. Because it's first this, then that. First he raised the issue. That happens when he takes the stand. That's the first time he says it's self-defense, because he felt threatened. After that, the state did nothing. Have I made up my mind? I think I have, Dana. I think I would rule that the assault charges were self-defense and the charge with Jimmy was manslaughter. I don't see it there. I don't see the need for him to go back. I realize it happened quickly, but Tyler Da Silva is being thrown out in the street when he's headed back in. And if as we found out that last blow, the one that killed Jimmy, happened after that, I realize it's in an instant, and it's like it's close, but I don't think that it was justified. I also didn't find intent to kill. I don't think there was intent to kill there. I did find him to be credible, and even supported as far as his version of the events by some of the accounts of the prosecution's witnesses. He was attacked first at the scene. Okay, I realize we're clouding things with having the Lazy Brook story and the other story mixed together. What happened at the first place? That's the charges have nothing to do with that. Nothing. That's just happens. Information. That's what happened first. So it's just clouding the waters a little bit. But I think a mixed verdict here would be appropriate. He says he stuck his hand out to make peace. The two of them both testified, even the one who was under oath, who had nothing to lose by lying, right? Because said that he went back to make peace. He went back to make peace. People were saying he was asking for Ayden. Ayden was the one he knew That's his boy. That's his friend. He was asking for his friend. The story checks out on that front. Now, as far as what happened here and the blow and this, that, and how I was down on my knee, I don't know. We don't know. We can't. I can't judge that. But I can tell you a lot of injuries on the lower extremities that usually in a fight you don't get down on the ground. Okay, getting somebody to the ground, that's getting them in a weak position. You don't go take a knee so I can stab them in the leg. No, I'm not buying that from the prosecutor. They overcharged with murder plus the immunity deals along with the self-defense probabilities gives me enough to say not guilty. All that matters, it shows intent. I think he showed intent to harm. I don't think they've proven he had intent to kill. And there's a difference there. I think there's enough of an element of self-defense where it was testified to, and the state admitted, first of all, he got assaulted first with WD-40 in the eye. And the state acknowledges that. I mean, as improbable it is, the state says, yeah, it happened. So we can accept that as fact. Then you've got him going back with his friend Tyler to make peace. They both testified that. The state's witness and the defense testified that they went back to make peace, that they got hit first when they were not fighting. Nobody saw the knife when they were coming up. No one saw him have a knife out. He didn't have a knife. He wasn't just going back to attack. But I don't know. It's gonna be a long Wednesday before we get back Thursday to this. What is going to happen tomorrow, though, is Brian Kohberger hearing is taking place. This is important because Brian Kohberger, if you have lived under a rock and not heard, Brian Kohberger is accepting a plea deal. He's going to plead guilty to 4 charges of murder. And in return, he's going to have the death penalty taken off the table. He will serve life without parole. If all goes as planned currently, that happens tomorrow. So the Brian Kohberger trial is off. It is done. It is nixed. It is wild. But yes, it is. It's that just broke yesterday. Broke last night. Amber, thanks for finding that. Amber's saving my. Let's see. Thank you. Thank you for saving this, Amber. I need to find that exact audio clip. So thank you for that. You gave me a timestamp. 3 hours, 44 minutes, 13 seconds. Day 17, Letitia's talc trial. I'll be there. All right. Is there any podcast tonight? Barb, we're doing the podcast on Thursday night, and it's going to be a wild one because I was given these little beans from Hades. They're bamboozled. Birdie Bot's every flavor beans. They're terrible. Let me just say, I don't even want to sniff the package. They have all different colors. It looks like Play-Doh in there. Just they've got everything. And I'm not excited about the different flavors they have. But I'll be eating 22 of those on Thursday. The parents are not happy with the deal that Kohberger made with the state, or the state made with Kohberger. They wanted the death penalty as an option. And they're actively fighting against it. So it's possible. There's still a chance the judge won't accept it for one reason or another. I can't see that happening. I think it's going to go down with an agreement. I think Brian Enton was right when he said, I think from the beginning, the state of Idaho did not want to prosecute this case. They did not want it. There are a couple signs that show that, but leave them outside so they mature. No. Don't listen to Donna Turner if she tells you to eat one. I have to eat the beans. I have to eat 22 of them. It's only some parents. I know it's split. I think there are 2 families that are definitely opposed to it. We are hoping that, Mags, there are some answers in the Brian Kohberger case, that if nothing else, the judge unseals the gag order. He releases the gag order, first of all, and then we get prosecutors that can talk to us, and then also unseals many of the documents that are currently sealed, some of the evidence that's in there. I realize some of it should remain sealed, I'm a fan of that. I'm a proponent of keeping some things sealed, but most of it should be open to the public. Let's see. Josh says I've got a palate cleanser clip. I've got an hour of Judge Middleton from this morning, and almost every case has something gold in it. It's pretty laid back. It's not like a fast-paced one, but he's just one of my favorite judges. Why 22? Because Thomas ate 22 last week. How do you know that the beans taste bad? They kind of look like chocolate. Truth be told, let me send you some. These are trick beans. Some of them taste like earwax, and some of them taste like buttered popcorn, but they look identical. So let's see. Here's a short. Josh, let me take a look at this. Trying to find it here. This is a fun one. I've never been here. This is a brand new court for me, Josh. Just one second. Okay, we're trying to find it right now. This is going to be 4 days ago. $25 long. Okay, we've got it. Here we go. This is a special find from Josh. Palate cleanser at the end of the day. Let me see. Oh, hang on. We need to go. We need to go 17 minutes in. Just one second. We're going 17 minutes in. Get to the right one. It's going to be short.
Trial will be tentatively scheduled in the August trial term. So
that's the end of the last one.
Mr. Pedersen, if you do post bail, you still need to appear on July 11th at 9:30 by Zoom. And if you do not, I'll see you on July 11th. All right. Take care.
Okay. That one's over.
Call my father, please, Mr. President. Yes, I will.
Tell him to bail me out. I like the soundproof foam on the back of the jail cell there.
All right.
The last matter I have is Mr. William Young.
And that is cause numbers 5A0609823 and 5A0609824.
I just have to say that I'm going into this box without any freedom to express myself freely. Oh, well, that's an oxymoron. Hi, guys. Ms. Rosano, Judge Rosano. I'm going to sit down.
Let me move out of the way.
Good morning, Mr. Young.
Yes, ma'am.
Going to be up here.
You're here for arraignment. Could you please state your full legal name?
William Marcus Young, V.
Thank you. Mr. Parent?
And Your Honor, he and I had a chance to meet in the breakout room. He understands the nature of the charges against him as well as the maximum penalties and the mandatory minimum penalties for the DUI charge. We waive formal reading of the complaints and enter pleas of not guilty to all charges.
He has a question.
Thank you. Not guilty pleas will enter. The court has previously had the opportunity to review the police reports, did make findings of probable cause. What is the city's request with regard to release and conditions?
Yeah, after reviewing Mr. Young's history, I'm not going to recommend bail. I will recommend standard DUI conditions for the cause ending in 823, as well conditions related to the DWS 3. I'll ask for PR as well for the resisting arrest with standard conditions at this time. I had noted in his history there may have been an incident.
Objection.
There may have been an incident in California, but because I'm an officer of the court, I couldn't tell from NCIC whether it was true or not. So I'm not going to offer up any type of information other than noting that it was in the federal information. Thank you, Your Honor.
All right.
Defense has no objection to standard conditions and release on personal recognizance. And sorry for interrupting so quickly there. I just wanted to make sure that Mr. Young didn't say something that could be detrimental.
All right. And Mr. Young, I do see that you want to be heard. In the court, we take turns. And as far as this, there's no jury here. So your objection to the city referring to your potential prior out of California, I think Mr. Johnson made it clear that he had no indication that it was accurate, that there was anything. So I'm not concerned about that. Did you have anything else that you wanted to say to the court? Mr. Johnson is recommending your release this morning with some conditions and to set court dates.
I'd rather not have any conditions. I feel I'm wrongly accused of a crime. And if he would like to follow that up, he could do that with you or my attorney or Ms. Gomez from California.
So at this,
sorry.
I'm sorry. And so
I have other lawyers in my wallet if they need to be present for any further questions.
I keep a lawyer in my wallet.
And so at this particular point in time, you do have an attorney here to represent you. You indicated an attorney out of California. If they're licensed in Washington, that'll be fine, but you do need to make sure that you have an attorney. I sounds like you want, and I encourage you to have an attorney present at your next court hearing. This is a preliminary hearing. The court reviews police reports, did make finding of probable cause as to the charges. With regard to future challenges to that probable cause, that can happen at your next hearing or can be noted by your counsel. So at this point in time, I am going to release you on the following conditions. You need to notify the court in person or in writing of any change of address, have no new criminal law violations for which there's probable cause, only use your true legal name and date of birth if contacted by law enforcement, do not drive unless you are properly licensed and insured, do not drive or be in physical control of a motor vehicle with a BAC reading of 0.08 or higher or a THC concentration of 5 nanograms per milliliter of whole blood or higher within 2 hours of driving.
No weed or booze.
Do not refuse a test of your breath or blood if reasonably requested by a law enforcement officer. That is my understanding of what the city had requested. Is there any objection to any of those conditions? I think, Mr. Parent, you already indicated there was not.
That's a good question. I do have a question.
You have a question? Okay.
Yes, ma'am. A purely legal question. Is it illegal to operate a vehicle non-commercially under the influence of your own religious institutional affairs medication?
So, Mr. Young, those are questions that are best answered by your attorney. The judge can't give legal advice to you.
Okay.
Right.
Thank you.
All right. So
I
with
smoke
that,
this for church. Is that what he just said? I smoke this for church.
I am going to set this matter for pretrial. I think we're setting these out to about July. Mr. Young, would you prefer to appear by Zoom or in person?
Probably in person. What city would it be?
It's in the city of Bothell.
Okay, that's not too far.
All right.
I like coming to court, but don't take me to jail. That'd be weird. I'm in jail now.
Understood. As long as you show up and you are not committing any new criminal law violations, the likelihood of that is very slim. Okay?
I'm on house arrest, essentially.
No, I just put conditions that are essentially that you need to comply with the law, especially the laws that are surrounding this offense.
I do.
With that, I'm going to set this matter for July 30th at 2:30 in the afternoon. That is either in person or by Zoom, so you can come in person if you'd like. Or if you change your mind and wish to appear by Zoom, that's available to you as well.
Thank you.
At this point, I did not see a request for court-appointed counsel, and it sounds like you have an attorney potentially already. Just make sure you let your attorney know that in this court, if you're appearing in person, they have to be in person. It is unrealistic for you to have meaningful conversation with your attorney in open court over the Zoom platform. So I think that, in my opinion, they need to be here if you're here. Okay?
Sure thing.
All right. So At this point in time, July 30th at 2:30, I'll see you either in person or by Zoom. Trial will be tentatively scheduled in the September trial term. All right. So with that, that should conclude this matter.
Are we done?
Yay. Thank you.
You're
Thank you,
welcome.
Sean. Thank you, Mara. Bye, guys.
It's Judge Rosano.
Can I say one more thing to you?
Oh, sure.
You have such awesome hair.
Thank you, sir.
Man. Woo. All right. Well, sir. Yes.
Probably should have
All
led
right.
with
I
that.
believe that concludes the 9:30 calendar.
I sure hope so.
Or we'll be in recess.
He should have led with the compliment instead of had that be in the tail end. All right. There we go. Awesome hair, Judge. Awesome hair. All right. A great palate cleanser. Let's see. We have fun things all around. This is going to wrap it up for today. Tomorrow, we've got a little bit of court hopping. So we've got a couple things we're going to listen to in the morning. Just realize that Idaho starts their day a little later than the rest of the country because they're on the western part of the country. So we won't check in with Idaho until 1 p.m. Eastern time. So the first part of the morning, we're going to talk a little bit about Brian Kohberger, maybe talk about some of the evidence, talk about some of the things that are happening, some of the latest news, because there's a lot of talk right now. A lot of people are talking about it. But we're also going to do some court hopping until Idaho comes online. Then we'll be following that here live on this channel, not on Top Mark Media, where we've been following most of those hearings so far. But on this channel, we'll follow the actual hearing. I will be listening intently for the instructions the judge gives at the end, specifically regarding the gag order. I would love to see that released. I'd love to see the documents opened up. As soon as that happens, I've got to get ready to start filing a bunch of FOIA requests. And might get prepped for that tonight as well to see where I need to send the money to get the documents. There's some stuff I want to see. I really want to see, and I think it's going to be opened up. Anyway, we're going to close the poll out before we end for the day. The poll we had was a rather simple one. Is Raul Valle guilty of murder and assault? 20% said guilty as charged, 47% guilty of lesser included, and 32% said not guilty. It was self-defense. So thank you very much for all your participation on that one. Bravo Chick comes in with a massive FOIA fund super chat. Thank you very much. I've got a couple people. I apologize. I missed 2 or 3 people during the end of last live stream that had sent a super chat or made a comment or an anniversary message, and they disappear when I start the new stream. I'm sorry. I try to recognize everybody. And to make sure I didn't miss anyone this time, Kelly H. began by gifting a membership. Thank you very much. Lois Cox says, I can share my points. Thank you. Helen Lewis, welcome to the gallery. Thank you so much. Love that blue courthouse. Dr. Bullbutter, member for 20 months. OG. Says, I'm going to go back to watching Suits on Netflix. Love y'all, everyone. It's a great show. Suits is great. Bravo Chick, thank you very much as well. I appreciate all of you. All right. That means that you guys get an early afternoon out, and we are going to... Oops, that's the wrong button. That was a loud one, too. We're going to be back tomorrow with some court hopping, some fun stuff in the morning, and then Brian Kohberger in the afternoon. And then we'll be back here in Connecticut with Raul on Thursday. That's July 3rd. July 4th is our nation's birthday, 249 years. Can you believe how old we are? Yeah, it's pretty young when it comes to nations, but hey, we're going to celebrate it. So Friday, 4th of July, we'll have the day off. There will be no live stream on that, but we will have the podcast Thursday night. So join us for that. I'm probably going to get sick. I'm serious. I mean, I'm eating yucky flavored beans on Thursday on the podcast, all live for your enjoyment. So, all right. Somebody said, send us to Lawyer No. I didn't know he was doing something, but we can take a quick peek. See where Peter Tragos is. Let's see. He's going to be with Nate Eaton. Oh, that's going to be awesome. But he's talking about Lori Vallow. Sounds good. It should be interesting. We'll jump over to him. All right, tonight when you go home, please hug the people you love, smile at someone, make their day just a little bit better, and please stay safe till we go live again tomorrow morning with some court hopping. Thank Thank you very much. Kelly H. Fist bump as well. Pound it. There it is. Pound it. All right. Have a good one. We'll have fun. There's a news conference on the Raul case right now. Ooh. I'll check it out. I can't air those, unfortunately. All right. Thank you very much. We'll see you guys. Have a good one. Bye-bye.
There's nothing in the order that restrains you from talking to cats.
Thank you.
Thank you, sir. You're my new best friend.
Shame on you.